everyone. Today we have Jacob Malatesta, litigation partner with Hagwood in Tipton. Jacob is licensed and practicing in Alabama, Arkansas, Georgia, Mississippi, North Carolina, and Tennessee. He represents clients including casinos, hotels, hospitals, and medical professionals. And he handles representative matters including premises liability, dram shop, and employment discrimination. Today, Jacob is going to be talking to you about but for COVID-19, trending causation theories in COVID-19 litigation. Please welcome Jacob.
Thank you so much. Like she said, my name is Jacob Malatesta. I always introduce myself whenever I begin talking, but I appreciate everybody tuning in to this. And this is a presentation on causation. And before we really kind of get into what I've seen and what it appears others have seen associated with causation in the world of litigation, particularly with regard to the retail, restaurant, and hospitality industry, I think it's important to make sure we understand our terms. What is causation when it comes to negligence cases across the United States? Well, the answer to that is that it depends. If each state has a different set or similar but different sets of factors that they look for. But today we'll sort of look at the restatements of torts, which is something that a lot of courts will rely upon for their analysis. And legal cause when it comes to negligence is usually comprised of two things. The first is the factual cause, and the second one is the proximate cause. Factual cause is what we're all used to, particularly if you're involved in litigation. It's the actual cause. It's the thing that actually caused the injury. In Latin terms, it's the sine qua non of the injury, but the way that we normally discuss this, or that's the simplest way of discussing it, is the but-for test. But for you're running that red light, there would not be an injury. But for you leaving the banana peel on the floor, I would not have fallen. And the second, that's the simplest, easiest way of discussing factual cause or actual cause. The second, more complicated factor associated with causation in litigation is proximate cause. And while it's normally something that is discussed alongside causation issues with regard to factual cause, it's really not so much an indication of legal causation as much as it is the scope of liability and reasonable foreseeability of an injury associated with the cause. In the restatement, they sort of give us a broad overview of cause, factual cause, the but-for cause, and then sort of begin to walk it back with regard to proximate cause. For example, in the restatement, it states that an actor's liability is limited to those harms that result from the risks that made the actor's conduct tortious. Put it another way, can Bessie's owner be liable for your lost profits? You'll all remember Bessie. She was the cow that started the Chicago fire. Well, imagine that I'm a resident of Chicago and my manuscript for the greatest film that's ever going to be recorded is in the back of my car. And as a result of the negligence of Bessie's owner, my lost profits go up in smoke. Well, can I recover from that? And normally the answer is no, because while Bessie's owner can reasonably foresee that a building might burn down as the result of Bessie knocking over a lamp, it's not reasonably foreseeable that a person would have a manuscript for the greatest film ever in the back of their car. So it's more of a limitation on liability than it is anything else. There are two types of people in the world. There are those who will admit that they do not completely understand proximate cause, and there are liars. It's extraordinarily difficult and squishy area of the law that doesn't make, quite frankly, a lot of sense, and it seems to be more result-driven than anything else. But regardless, proximate cause is an important part of litigation. Next slide, please. We also, when you discuss causation issues in general, I know that a lot of times when I have discussions with my client, I'll say, well, we have an issue here with regard to cause, with causation. And they'll usually say, that's right, because we didn't do anything wrong. Well, that may be true. We didn't do anything wrong. But from a causation standpoint, particularly when it comes to motions for summary judgment or getting cases dismissed, we must start from the position of negligent conduct. We must start from the position that we had a duty to do or not to do something, and we breached that duty. As we'll talk about later, you want to avoid proximate cause when it comes to developing a defense for a judge, because it's squishy, it's hard to determine. So from this point forward, let's all sort of assume that we had a duty to abide by the CDC guidelines, abide by the state-specific mandates, whether it was a mask mandate, disinfectant mandate, number of people in a store mandate. Let's all assume that we had that mandate, we had a duty to do it, and then we breached that duty. We didn't make people wear masks, we didn't disinfect the place. Moving on to the next slide. So what does it take to prove the but-for causation? Beginning with that, what does a plaintiff need to show in order to show that that they have been harmed? They're going to need to show that but for your negligence or but for your duty in actually forcing people to wear masks or disinfecting a room or keeping the number of tenants down or keeping the number of people in the store down, they would not have suffered from COVID-19. And so far, there have been really sort of three areas where this has come up and plaintiffs have tried to do that. The first is the Princess Cruise Line cases. These were some of the very first litigable cases to be filed. They were filed in the Central District of California, and they all involve cruise ships and people who caught COVID while they were on cruise ships in the Pacific. In those cases, the judges have dismissed a number of them because, for example, in one case, there was the Rumrills. They alleged that they contracted COVID-19 on the Ruby Princess. And as a result of the cruise line's failures to implement proper policies and procedures. The judge said that the plaintiffs failed to allege the amount of time between the alleged exposure and the date they began experiencing COVID-19 symptoms or had a positive test result. As a result, there was no but-for causation. But the plaintiff was allowed to amend their complaint to allege that. That's important because while the judge was willing to sort of say this is the end of this litigation, at the same time the judge allowed them to amend the complaint and gave them a roadmap to providing the proper evidence to show that they were in fact exposed to COVID while they were on the ship. Now, it's going to be very rare that you have a plaintiff where they were on a ship for a very long period of time and contracted COVID, and there's no way, and you can specifically say that they were exposed to COVID while they were on the ship. They were in the middle of the ocean, they were only on your premises the entire time, and as a result, they contracted COVID. So the timeline is incredibly important. The other way that I think plaintiffs are going to do this is through experts. The experts are going to say, well, it's more likely than not that, based on my expert opinion, that the plaintiff was exposed to COVID while they were inside your restaurant because of X, Y, and Z. They have to, it's important for them to use that more likely than not language, but more likely what you're going to end up seeing is experts who say it's consistent with. Yes, that they caught COVID while they were in your hotel is consistent with the fact that you didn't disinfect. The first one is more likely to get in. The second is not, but you're still going to see that because there's a lot of money to be made associated with these cases. One of the reasons I wanted to talk about this was because while causation appears to be the biggest hurdle for plaintiffs to overcome, that doesn't mean they're going to stop because of the hurdle. And that brings us to what has been discussed and what most folks think will be the actual theory that most plaintiffs use, and that is the public nuisance doctrine. The public nuisance doctrine is generally invoked when one person's use of their property injured the public's health, comfort, or morals. Typical examples include diverting water and benefiting oneself at the expense of the public. The most famous use of the doctrine was when it came to oil spills. People were held civilly liable under the public nuisance doctrine. But even then, back in the 80s with the oil spills, they were limited to specific people. In other words, fishermen were allowed to sue in the public nuisance doctrine. People who had their livelihoods affected. Landowners were not. As with all things, the public nuisance doctrine has expanded significantly, and they're essentially going to allege that you caused a public health disaster. These types of claims are usually brought by a municipality or a class, but I'll guarantee you that you're going to start seeing cash-strapped municipalities are going to be willing to agree to contracts, contingency fee contracts with plaintiffs' attorneys to bring these claims against specific businesses and individuals. There is, in fact, already an several employment claims that have been brought by groups of employees against manufacturers, particularly in a chicken plant, alleging that they knew or should have known about the ongoing public health crisis that was occurring in their manufacturing facility, but they did not do anything about it. Going on to the next slide, there is finally the how we're going to battle this. And what you often see is, well, Your Honor, the plaintiff bears the burden of proof for causation. And that's usually what you're going to get right there. The judge is going to roll their eyes. They're going to tell you have a losing argument. And they're going to explain to you that a question of fact is a question of fact. Going on to the next slide. As a result, we are sort of preparing ourselves to defend these cases. I do a lot of work with social media. And I can tell you that one of the biggest hurdles I face in trying to get social media information is relevancy to the specific cause of action. In this case, knowing the plaintiff through social media, through check-ins, through location applications on phones and devices, as well as text messaging and potentially even phone records. For the first time ever, where somebody's phone dinged off of what tower may actually do something to help in a civil litigation case, because it's going to tell us where the plaintiff was. They might allege that they were doing nothing but quarantining the entire time, and in fact, they were not. Experts are going to be huge in this area. In fact, we're going to need to make sure that our experts explain the silliness associated with opinions that are consistent with our liability, and epidemiologists and virologists are also going to be important. Going on to the next slide. In the event that there are workers' compensation questions, I wanted to make sure that folks understood that in workers' compensation, there is a substantially lower burden for causation. Generally, you must only show that it occurs in the course of the employment and that it arises out of the employment. Occupational diseases are also something that I think a lot of folks are going to see plaintiffs in workers' compensation cases allege. And there are three factors for that. In fact, one of the very first lawsuits was basically a comp claim filed in 2020 for the wrongful death of a worker in April 2020. If you'll recall, this really sort of exploded in the middle of March, and within 2 weeks, there was already an employment claim. That is all that I have for you. Hopefully I haven't taken too much of your time. I do appreciate your time. I look forward to discussing this further with everyone in more detail in the group discussions. Thank you so much.
Thank you so much, Jacob. This was fantastic and very insightful information. For those of you that are watching, you'll be able to view on the agenda exactly when Jacob is hosting his Deeper Dive Roundtable and join him then. Thank you again, and we look forward to talking to you soon.
Thank you much.